noise in the background, or has the potential to do that, mobile phones and such like. And please be aware that this meeting should be available on the DPA webcasting site in due course. If you have to leave, please leave. If there's an emergency, don't hesitate to do that. Now, we may have some different people around the virtual table than our compared to our first meeting. So I'm going to ask all the lead spokespersons just to introduce themselves and the party quickly, and that will test that everyone can hear each other. So, Mr. Trinick, for the applicant, could I ask you to introduce?
Yes, thank you, sir. I'm Marcus Trinick, the advocate for the applicant. I can see we've got from our team on the call, Graham Blackett, Fraser Gillis, Graham Kerr, Amy McDougall, Imran Abbasi, and I don't know who Galaxy J5 is, but I don't think he's one of ours. Thank you.
Thank you, Mr. Trinick. And for the council?
So it's James Finlay from the council. I can see Karen Lyons and Roddy Dahl from the council, and Simon Heinsohn, also from the council, and Debbie Green from Nature Scott. Just like to note the change of terminology from SNH to Nature Scott. Karen Reid, I imagine, is GMKR, also from Nature Scott.
Thank you. And for the National Park?
It's Nina Caudry, Planning Officer for the National Park.
Thank you. And Mr. Kelly?
Good afternoon, sir. Yes, I'm here representing the John Muir Trust and Wild Land Limited. There's just myself. And as I explained in an email, which I hope some have seen, unfortunately, we have workmen in the apartment just now, so there will be noises off, and I may have to occasionally leave the call, but it shouldn't disrupt proceedings. Thank you.
Okay, thank you for letting us know that. You may have seen that Mountaineering in Scotland couldn't be present today, but they have sent round some notes on the agenda, which I hope you have all seen. If you haven't seen them, then please let me know now. Okay, looks as if everyone's seen the notes from Mountaineering Scotland. The purpose of today's meeting is to have a further discussion around arrangements and procedures for the case. As ever, the merits of the evidence won't be discussed. Before I move on to the agenda proper, which I assume you all have a copy in front of you or on the screen, I'd like to thank you all for your constructive way that you've approached the written submissions to date. That's been very helpful, and we've been able to progress matters. Please also have a copy of the note of the first meeting to hand, just in case that we need to refer to that. That's the meeting of the 14th of May. I don't plan to go over ground that was agreed at that meeting, and I will do a note of this meeting. It won't necessarily supersede it, but it will deal with matters that we need to discuss today. So before I go on to item 2, is there any burning questions before we can get on to the agenda? No, okay, that's great. So the second item was the progress on written submissions. Short item. We agreed a lengthy list of written submissions, and we've made significant progress in achieving the deadlines that were set. As far as I can recollect, there are 2 deadlines that are still to be completed, and that's for parties to make comments on the additional information that I requested for the purposes of the inquiry, which is the cumulative assessment and Pete slide. That's by the 28th of August, and then the applicant has an opportunity to respond by the 11th of September. As far as I'm aware, other than matters relating to oral sessions, there are no other deadlines for written submissions outstanding. Is that everyone's understanding? Yes, nods. Right, that's all I really want to do in that item, just a quick review, and we can move on then to item 3, which is the current DPA guidance with regard to COVID-19. I hope you'll be aware that our latest guidance was issued on the 14th of July. In summary, it allows for oral proceedings to take place with measures and procedures in place. All of these measures and procedures need to be in line with that guidance of June 14th or any other guidance that would be in place by November. You'll recognise that guidance could change and possibly at short notice. You may also be aware that the DPA are involved in other inquiries in advance of the inquiry for this case, and it's likely that our procedures may be informed by those earlier events. A protocol along with risk assessments will be shared in advance with all the parties, and an opportunity for consultation on that protocol. And we'll go into that in a bit more detail at item 9. But just now I just wanted to highlight the implications of the current guidance, i.e. that oral proceedings can proceed if necessary. And with regard to site visits, the current guidance indicates that accompanied site visits can take place in circumstances where it is required, and that the reporter is satisfied that it can be undertaken safely. Any party involved in an accompanied site inspection would be required to adhere to the current guidance, including physical distancing. And we'll come on to talk about that in item 7. So are all the parties aware of our current guidance of the 14th of July, its implications in terms of what we had agreed previously, and are we happy that we discuss the detail under item 9, which is the second item 9 on the agenda, and item 7? Everyone happy? Thank you very much. Okay, so that's our current guidance. It's on our website if we need to, any of the parties need to look at it. If it does change, we will let the parties know. So item 4, a discussion on procedures for considering energy and planning policy and economic benefit matters. Since we last met, we've had a number of written representations as we agreed on these topics. I'm aware of the applicant's view on further procedures and recommending a hearing subject to caveats. The Island Council are indicating that at this moment in time a hearing may not be required and that written submissions may be sufficient, as do the National Park. I've noted, having read the material on the agenda, an option for discussion around 2 hearings, one covering energy and planning policy and the second covering economic benefits. From the response, Mountaineering Scotland are happy with that approach, but I'm aware that Mr. Kelly has indicated that I think a preference for an inquiry session. So I think it's useful to have a discussion around the procedure that we will agree on the topics of energy and planning policy and economic benefits. And perhaps if I could first turn to the applicant, Mr. Trinick, if you could kick off with your thoughts on having two separate and focused hearings.
Yes, thanks, sir. I'm pretty agnostic as to whether we have one hearing session or 2. It could be a single session divided into 2. It could be 2 sessions. I'm not really too worried about that. We are very keen for there to be hearing sessions rather than an inquiry session, because perhaps the main reason is we've got a number of witnesses who are going to appear, and some of their evidence does overlap, and I can see difficulties with inquiry sessions of the poor old advocate on the other side thinking who to ask a particular question. There are overlaps between my witnesses. So having a hearing session gets around that difficulty very nicely. Put all the witnesses up there at the same time. I do think that we need oral process to answer Highland Council's question, but we really do want oral process to discuss in particular economic benefits and, as David Gordon says, disbenefits, no doubt, of the project.
Thank you, Mr. Trinick. And Mr. Finlay for the council.
Well, the joint view of Council and Nature Scott is that it could be done by written process. There's no need for oral process, but if there is to be an oral process, we agree with Mr. Trinick, it should be a hearing. I noted in the applicant's response to latest response on policy, they wish to have some input into the agenda, which seemed to us to be slightly unusual by way of an approach. We're concerned that any hearing, if such does take place, doesn't become a process for like grandstanding benefits. It's used as it should be appropriately used to answer any outstanding queries you have and to inform you in your writing your report. We've set out our position, and I don't think I can usefully expand on it further than that unless I can help you further.
Thank you, Mr. Finlay. Just on the point of contributing to an agenda, during the preparation of hearing agendas, we do circulate in advance, and we do allow comments to be made on agendas. So I don't see anything particularly different happening, and I've kind of allowed for that in terms of a draft agenda to be sent out and for responses to come back on that. The likelihood is that I would, consider those points and then conclude on the agenda. It won't necessarily be an agreed agenda, but between all the parties, it'll be the agenda that I consider most appropriate. But to include that opportunity for consultation and for me to take on board the points that all the parties make in response to that draft agenda. I think one of the points that the applicant was making was for the agenda to be detailed so that matters are expected to come up and that there are no surprises. So I would certainly hope to be as detailed as I can in terms of the drafting of an agenda. Mr. Finlay, do you have any thoughts on separate hearings for policy matters and economic benefit?
We don't think a separate hearing is necessary. They're quite commonly done together, and we're likely to be fielding the same witnesses for both in any event. So we don't think there's a great deal to be gained from having separate hearings.
Just before anyone else comes in, I mean, one of the reasons was just to separate out the number of people in the room. That was part of the reasoning, and that there seemed to be a suggestion from some parties that 2 hearings was of benefit. But one of the key matters was just to make sure that we had separated out participants as much as possible. For the national park, do you have any thoughts other than what you've already indicated?
No, I mean, it remains as we submitted, that we would prefer written submissions. We're only commenting in relation to the national park, so we wouldn't want to be involved in a separate hearing session about energy policy, but we're happy to take your direction.
And Mr. Kelly.
Thank you, sir. I'm not sure where the impression came that I was looking for an inquiry. I hope I haven't misled anyone. We'd be perfectly content with a hearing session on policy and economics, and I'm quite agnostic, as Mr. Trinick has said himself, about whether it's 1 or 2 sessions, but certainly we're of the view that there should be oral evidence, and perfectly happy with a hearing format.
So Mike, can come in there a moment.
Yes, Mr. Trinnick.
Thank you. Yeah, you've raised there a point which would be of concern if it impacted. In connection with the September inquiry, starting next week, there has been a COVID protocol which is limiting the number of participants in the room at one time. Now, I said about the hearing session that an advantage to us was that all my witnesses could be there at one time because of overlapping evidence. Now, obviously, if the protocol is going to prevent that, then I would wish to return to an inquiry session rather than go to written reps or any other format. So that may need to be cleared early because it's important that all of my witnesses are present at one time. Therefore, 5 in the room, myself and 4 witnesses for the economic session. If there were separate sessions, I would only need myself and my planner, so 2 for the policy session.
Okay. Does the number of participants affect any of the other parties? You're not expecting to have a significant number attending. And do you think it raises any issues if the applicant has slightly more bodies in attendance? The key matter is that I hear the evidence and receive answers to questions and allow questioning. Is there any issue arising from one party having slightly more in attendance, Mr. Finlay?
No, and it's quite common that the applicant will have a number of witnesses, greater number of witnesses on these combined issues than the other parties.
Well, as I indicated, we will learn from and then issue our own protocol for this particular case, and I think I'll bear that in mind for any protocol, Mr. Trinnick, that at the moment I don't see it being a problem in terms of the number of parties and the size of the room and the target and number or the maximum number allowed in the room by the hotel, and we'll go on to that later. So I don't see that to be problematic. It may be more problematic if there's a larger number of parties. From what we've discussed, I'm quite content that we have one hearing, but we do split it up to allow the potential for witnesses to disappear, deal with the policy matters first and then economic benefits, although there might be a little bit of crossover, and that will be determined through the drafting of the agenda. So if everyone's content, I'll note down that after hearing your submissions, my preference is for a hearing, and that will try and divide up the agenda in such a way to minimise the number of participants. Are all the parties content with that? No other comments to make. I mean, for the applicant, is a day in terms of the time required sufficient to allocate at the moment? I wouldn't be suggesting we allocate any more, Mr. Trinnick.
1 day is fine. I think it'll be less than a day, but 1 day is plenty.
Okay. Any other comments from the parties on the time required? No. Okay. Can I just check the parties who would take part? I'm quite clear that Mr. Trinnick, the applicant, and the council and SNH would take part, although it wasn't a preference. Mr. Kelly, you've indicated you take part, and the National Park, I think you've indicated you take part, albeit your evidence will be focused. And I know that Mountaineering Scotland have indicated that they would wish to take part. So that's all parties wishing to take part in this hearing. Am I correct? Yes? Okay. Well, I'll make sure I cover all that in my note. Is there anything else on this item before we move on? We've agreed a hearing 1 day and for it to cover socio-economic matters and policy matters. No, okay, I can move on. Thank you very much. The next item is really just to go over the arrangements for the procedures for landscape, visual, cumulative wildland national park impacts. We previously agreed 2 separate inquiry sessions. One question I have, I think, is for the national park in terms of inquiry topic 1. I just want to double check that you were planning to take part in that inquiry session. From recent correspondence, I wasn't sure if you were or not.
No, SNH, or sorry, Nature Scott are representing us in terms of effects on the park.
Yes. Thank you.
Yeah,
That clarifies my understanding. Thank you, Mr. Finlay. That was the one question I had on inquiry topic 1, and I'll clarify the parties. Otherwise, everyone happy with the running order with the applicant, Council and SNH, John Muir Trust, Wildland, and Mountaineering Scotland, that being the running order for inquiry session 1. Inquiry session 2 was with regard to wildland. Can I just check that I got it right in the note, the applicant, the Council and SNH, and then John Muir Trust and Wildland. So 3 parties there for that topic. Yes, that's clear. One question is, I assume that any inquiry report would be joint. You wouldn't plan to separate your inquiry reports for the sessions, or have you got any thoughts or views on that? Are all the parties planning on preparing a single inquiry report? Mr. Trinick?
There'll be 2, sir, because I've got 2 witnesses.
Okay.
One dealing with one topic, one with the other.
Okay. And Mr. Finlay?
We have 2 witnesses, but our Nature Scott witness will be preparing one report in 2 parts, dealing with the second part dealing with wildland, the first part dealing with primarily the impact on the qualities of the park. There will also be a witness from Highland Council dealing with visual and other impacts.
Okay, and Mr. Kelly?
There will be 2 witnesses. I will give very limited evidence on inquiry session 1. Dr. Carver will give much more detailed evidence in relation to the inquiry session 2, and there will be separate inquiry reports for both sessions, but for inquiry session 1 it will be relatively short. The bulk of the evidence will be for inquiry session 2.
Okay, dokie. And I don't need to ask that question of the national park. Is it fair then that I leave it to the parties to decide how they want to present their inquiry reports? There may be a slight difference in terms of 2 or a joint in 2 parts. Everyone content that the parties prepare their inquiry reports as they see fit with regard to the witnesses? Yeah. Okay. Is there anything that any of the parties would like to raise with regard to the inquiry sessions in terms of procedures for the moment?
Can I just raise one point? And it's really a question of from Mr. Trinick, and it's really in terms, I should perhaps have raised it under policy, but it's the extent to which wildland policy issues are likely to be in dispute, if at all. As I understand it, the assessment that's been carried out on the latest Nature Scott approach, there have been, it was just an indication of that, so that to see whether, to what extent we needed a Nature Scott witness to be present. I'm not asking for any detailed response at this stage, or but it would be useful to have some feedback.
Mr. Trinick, would you like to respond?
Yeah, I think I can confirm that the Mr. Welch, who will be my witness on wildland, will be addressing matters by reference to the still draft, but nonetheless the 2017 guidance and not the 2007 guidance. if that helps.
That's extremely helpful and should cut down the policy session aspects of that issue. That's very helpful indeed. Thank you very much, Mr. Trinick.
Thank you, Mr. Drink. I think that echoes what was in the note of the our previous meeting. Mr. Kelly.
The work that will be undertaken, it's just learning what was said from what was said at the lime kiln 2 inquiry, where Dr. Carver also gave evidence. His evidence and the approach to his evidence in mapping the effects of the developments on wild land might well raise some issues that would be better answered by SNH rather than the applicants. So it's not for us to say, but in terms of definitely asking for them to be there, but it's just that you might find it helpful if SNH were present when Dr. Carver gave his evidence.
Am I correct in that Mr. Finlay, you'll be representing the council and SNH in that session?
Yes, I will.
Yeah.
And in the wildland evidence, I only have wildland session. I will only have one witness, who is in fact Cara Anderson, who's a consultant working for SNH, but is reasonably familiar with their policies and indeed gave evidence at the conjoined Drumholliston lime kilns inquiry in a simple.
Okay, thank you, Mr. Finlay. Mr. Kelly, Mr. Finlay's clarified the arrangements. Mr. Trinick.
Yeah, just on this, on the wildland evidence, we now know from an exchange of emails that Dr. Carver will be addressing not just WLA 19, which is the nearest wildland area, but also 14, 15, 20, and 24. So we have five wildland areas. Now, that's perhaps more than we expected. That's not a criticism. They must see that produce their case as they see fit. But it does have implications for the timing of the session, the amount of time it will be taken to deal with the evidence, and perhaps also for your site visits, if you're going to be asked to visit not just one wildland area, but 5. I wonder if Mr. Kelly wanted to just confirm the scope of Dr. Carver's evidence there. Sorry, just to finish. I asked that partly because I
jump in advance.
The experience of cross-examining Dr. Carver at Limekiln, so I do know how long this evidence takes.
Thank you, Mr. Trinick. Mr. Kelly did provide a scope of evidence, and it's captured in the note, and that they would be addressing effects on wildland areas 19, 20, and lesser effects on 14. Can I just clarify, Mr. Kelly, has that changed in 19, 20, and 14?
Sir, the position is until the mapping work is done, I don't know the full extent of the evidence, and that's why I was pressing for early access to the data for Dr. Carver to carry out his mapping work. Unfortunately, that looks as though it will now be sorted out. I still think the bulk of the evidence will relate to those 3 areas. The other wildland areas raised by Dr. Carver are more distant, and he was just talking about the possibility of there being some effects on views from the summits. Now, what I will do is, without releasing our evidence in advance of the due dates, I'll ask Dr. Carver to proceed with his mapping work as quickly as possible, and then I will ask him to tell me which are likely to be the wildland areas most addressed in his evidence, and as soon as I know that, I will confirm it to the parties. My own current assessment is still as per the minute of the meeting, but I need to see the mapping.
So if I may just come back on that. Yeah, you say mainly focus. The trouble is if you focus at all on any area, we're bound to answer what you say or what Dr. Carver will say. And that involves Mr. Welch doing further site work, perhaps. The inquiry is in November. Mr. Welch and I are on an inquiry for 3 weeks starting next week in Murray, as you know. So time is getting very short to amplify the case beyond the note of the pre-inquiry meeting. So can I have some clarity as to when Dr. Carver will crystallise which of the wildland areas he's going to address? I don't mean in detail, I mean at all.
Mr. Kelly.
The data which we requested from various parties has not yet been received. It's been promised. I've been told by SSC that their data will be received tomorrow morning at the latest. I'm still waiting on Mr. Gillis telling me when the Dell data will be available. I'm quite happy for you to set a date, sir, by which time we have to clarify what we're going to address in evidence. I understand the concerns, but at the same time, I do want to have the mapping done so that I can understand the issues from the perspective of the effects on wild land. But I'm quite happy to look at a date set by you to confirm the position, sir.
Any other parties have anything to contribute at the council? And for the national park, Mr. Trinick, I think you're looking to come back in there.
It is just a question of timing here. You're wanting us to exchange evidence on the 2nd of October, which is roughly 10 days or maybe 15 days after Mr. Welch comes out of the inquiry starting next week. We are not just short of time, we are grossly short of time to address any new wildland areas not previously notified.
Well, if you will have seen my the note that went around with regard to time scales and deadlines, and that is that we do have some scope. Perhaps once we discuss those timetables later on, we could revisit this matter. If we agree amended timetables, then perhaps that might give you the degree of comfort that you need, Mr. Trinick. So if we could potentially park that for the moment, and once we go on to the discussion on the timetable and the submission dates, if there's remaining concerns, then we can deal with them there. Okay. Are we happy to move on that basis? Okay.
Yes.
Thank you, Mr. Trinick. Item 6 was a quick discussion with regard to conditions and legal agreement. Based on what I've seen, I do believe there is a need for a hearing on the matter, albeit it may not be a full day hearing. We have the applicant's position and the council's views have been put together, and I think there was a willingness to try and refine that further in terms of a set of conditions and the applicant and the council's view on those, and the submission of a final statement in advance of a hearing. Is that still your position between the applicant and the council, still looking to refine matters further to submit a final statement in advance of a hearing? Mr. Trinick.
Yes, I'm not quite sure in whose court the matter sits in terms of any future refinement, but yes, certainly we will work with Highland Council to refine any differences as far as we can, and we will commit to sending in an update in advance of the inquiry. That's absolutely fine. Just one thing on the timing of the hearing session. You might wish to consider putting it at the end of the day, where we have the hearing session on economics and policy. That may not take the whole day, and it'd be a good use of time to continue and get rid of conditions at the same time. Otherwise, what may end up, you get an orphan topic for which you need another day you hadn't planned on.
Thank you for that, Mr. Trent. We'll bear that in mind when we discuss the programme later on. Mr. Finlay?
Yeah, I would agree. Firstly, Highland Council are more than happy to continue to work to refine the areas of disagreement, such as they are, to reduce the scope for that. And secondly, I agree with Mr. Trinick's suggestion of trying to fit it into the same day, because there will be certainly a coincidence, or likely to be a coincidence, of witnesses, and it would probably make for smooth running of the inquiry session to do that.
Thank you. Anyone else wanting to contribute at the moment? Mountaineering Scotland will not want to participate in the hearing. National Park, would you be? You wouldn't be participating in the conditions hearing. And Mr. Kelly.
The intention is that we would be there. I doubt if there's very much we have to contribute, but given the running order, anticipated running order, I would be there present in the room anyway.
And for this topic, are all the parties content that we will be looking at one single statement from, we'll probably in the note have it down for the council to lead on pulling that together. But everyone happy that we're dealing with one document that I'll be asking questions on? Yep. Okay, thank you. So that actually takes us on to item 7, which is accompanied site visit. I touched on that in the update on our current guidance. And I just want to double check, one, that the applicant is still wishing a accompanied visit to the site itself. Obviously the circumstances of arriving at the site might not be straightforward in the current arrangements, but it may be possible. And have you had further thoughts on how the arrangements may work for that, Mr. Trinick?
Yes, I have. I'm reading a very recent WhatsApp on it, so forgive me while I stumble my way through it. Yes, we can accommodate a site visit. We can provide drivers. We can provide the number of vehicles required. We would need to know just how many parties want to come on the accompanied visit, but it can be done. We just need to refine matters and arrange also for a COVID risk assessment to be carried out for those attending. It's all doable, and yes, we would like that visit.
Thank you, Mr. Trinick. Are any of the parties not keen to come along to that accompanied site visit?
So for my joint parties, and this may or may not include the Park Authority, we will give some thought as to how many witnesses we need to have along. If it's simply going to be a visit to the site, it may be that one witness from one of the 3 that I've just mentioned will suffice, but we'll inform you of that in due course.
And Mr. Kelly?
At the moment, my thinking is that I wouldn't need to go along to this to simply help with the numbers and reduce the logistical issues. Like Mr. Finlay, I'll think about it, but at the moment, my inclination is not to insist on being a party to that accompanied site visit to the site.
And for the National Park?
Yeah, I just agree with what Mr. Finlay said. We'll work it out amongst ourselves, but as the Highland Council and SNH are representing the Park Authority, it would probably make more sense if they attended rather than myself.
Now, there may be, depending upon the guidance at the time, reporters at the moment are using separate cars, driving separate cars to locations for accompanied site visits. So being in a vehicle with someone else may be difficult. I haven't bottomed that out yet, but that's something to bear in mind, whether or not people have to arrive at a meeting point under their own steam, or that travel arrangements and vehicles are provided by the applicant. It would be useful, I think, in order that the applicant can make arrangements that we're all able to confirm by a certain date our intentions, and that will allow the applicant, to carry out the necessary risk assessments and for the DPA to compare that and see how that matches up with our current guidance. would what sort of timescale do you think that you would want to know that information, Mr. Trinick?
It is necessary to liaise with the Glenshero estate people. I would ask for it to be, those arrangements to be completed by early October. Assuming that the visit takes place, I think it's the day before the inquiry or thereabouts. Is that what you're aiming for?
We had indicated it in the note that it would be Monday the 9th. Probably the afternoon, I would guess. Certainly not early in the morning, or we might not be able to see much. My thoughts were that it would be early afternoon in order to get take advantage of any opportunity that the weather might provide for us, and then into the inquiry the next day. So the actual first day of the actual inquiry would be the Tuesday. Are all parties happy with that arrangement, Mr. Trinick?
Well, having just done a site visit, it's going to take more than an afternoon, I'm afraid. It's quite a long venture to get up on site and see it and come back down again.
Yeah, it was really to be there. Sorry, to be actually at the site itself for the kind of middle of the day.
Okay, can I suggest, because if we try to sort out the micro planning now, it's not going to work. If we put a proposal to you and to all parties for how it might work, you can come back to us.
Thank you, Mr. Trinick. I think what we'll do is Mr. Finlay.
Just thinking that further through, and your reference, which is obvious, to the point that it's the day before the inquiry might start, depending on who's attending the site visit and how long it might take, and picking up Mr. Trinick's point on that, may not be the most appropriate date for either of us to have our wildland witnesses away from the evidence, unavailable to the advocates. That's an issue that could be sorted through timetabling, so that wildland wasn't on the first 2 or 3 days. It's easier for Mr. Trinick, who has 2 separate witnesses, whereas I have one witness will be appearing on for both inquiry sessions. But if I could just ask, if the date remains the 9th of November, perhaps I could ask that be taken into account.
Mr. Trinick, do you have anything in response to that?
Yeah, I mean, Mr. Finlay makes a very fair point. I understand exactly what he's saying. It's not so far north, this particular visit. It's not like going north of Inverness and having to do it twice. You're only what, 3 hours north of wherever you're based at the most. So if we did it in the week before, or even some time before that, that wouldn't hurt, would it? Is that doable for you?
For me personally, I'm fairly flexible. It was really just to kind of align it with the inquiry. If there's a preference from all parties that we do that at a separate time, independent to the inquiry, but perhaps before, then I'm very comfortable with that. That would provide potentially the opportunity to reschedule for weather and such like. So if there was agreement around the table that we tried for an earlier accompanied site visit, we may even suggest a few dates because weather might not be with us. I'm completely content with that. The only reason it was for the Monday it was because it was to align it with the inquiry itself. If there's now a preference separate from the oral evidence, then I'm more than happy with that. If all the parties would be content with working through a date in advance and working through the arrangements that we need to do, then I'd be happy to agree that today, Mr. Trinick.
Okay, that seems very sensible to us. So if we put together a proposal for what will be done, how it will be done, and some suggested dates and an email to you, to the case officer.
I think if that's sent to the case officer, what would be useful first, I think, is if all the parties can confirm to everyone the number of bodies that would be involved, just so you've got an idea of that, Mr. Trinick. Mr. Finlay.
Yes, well, I'm very grateful, and I see no trouble with liaison on that basis, and it'd be a maximum of 2 from the council, but and Nature Scott, but we will, I'm sure we'll be able to confirm that within a week as to whether it'll be 2 or 1, and then we can easily liaise either directly or through the case officer as to a number of date options at which the witnesses were available.
Mr. Kelly?
Yes, I'm quite happy to consider other dates. No problem at all. If we attend, it will just be myself. There'll only be one person.
Okay, yeah. Now, please don't remove this date from your diary quite yet, though, just in case we don't manage to visit the site. But on that basis, we can revisit just as we go through the agenda, the start date and the start day, if you like, for the inquiry. And that's really the next item. It's just based on our brief discussion so far, just have an overview of a programme, because I have indicated that we are likely to issue an inquiry programme just to help manage the sessions and a number of people in rooms and such like. So under item 8, there's a number of bullet points. Accompanied site visit, it was down there for the 9th of November, but what we've agreed is we would try and agree dates at an earlier stage. Inquiry session 1, on the basis that we might still need the Monday for a site visit, are all parties content that we start on the Tuesday? So Tuesday the 10th for our sessions in the Osprey room. Mr. Trinick?
Yes.
Everyone happy with that? Everyone's nodding, that's great. Your feelings on inquiry session 1 and 2 in terms of the number of days, based on your thoughts so far. Mr. Trinick?
Sorry, so I'm not quite sure what the question is.
Your estimate of number of days for inquiry session 1 and 2.
Okay, yeah, sorry. Inquiry session 1, certainly my guess is, well, that could take less than a day. Inquiry session 2, just less than a day. So if you allow for the Tuesday and Wednesday, I think we'll get through that. Maybe trespassing on Thursday, but doubtful. Still leaving enough room to complete the hearing sessions well before the end of the week.
So Mr. Trinick has suggested that we may be able to complete all oral sessions by the end of 4 days. Did I hear you right there, Mr. Trinick?
Yes.
Yes. Mr. Finlay?
I would suggest a more cautious approach, irrespective of Dr. Carver's involvement. I would hope that we could deal with all the inquiry sessions in the first week, but it would be sensible to allow a spillover day of 1 day, and then in the following week. And then the hearing session should be 1 day. So it may be that Mr. Trinick is right and we make quicker progress, but in terms of setting aside time at this stage, I would suggest a more cautious approach.
So you're suggesting 6 days, 4 in the first and 2 in the second?
Yeah.
Mr. Kelly, any thoughts on that?
I had anticipated that inquiry sessions 1 and 2 might occupy the whole of the first 4 days, and then have a separate day in week 2 for the hearing sessions. In relation to inquiry session 2, Dr. Carver will be coming up from Leeds to give his evidence, and as the programme evolves, I was hoping to be able to get a fixed day for his evidence at some point in week 1. So in short, my thinking is 4 days for all of the landscape evidence and an extra day for the hearings.
Okay. Well, when we do put the programme together, which will be circulated for comment, we will be looking to fix within reason the timetable simply to manage and adhere to our risk protocols. That's not to say there won't be some flexibility, but we will try and set schedules across the programme. Mr. Finlay, I think you're looking to come in. So if we're looking at 2 days for inquiry session 1 max, 2 days for inquiry session 2, does 1 day in the following week give any of the parties problems? We could, if you wished, we could start on the Monday and forget the Monday as a site inspection. If there's a degree of confidence around all the parties that 5 days sitting will be able to cover this, then we could potentially look at that, Mr. Trinick.
I'm just a bit puzzled by the pessimism from Mr. Finlay and Mr. Kelly. I wonder if you just go around and take some. Let's just go through witness by witness and do some timing here, because I don't quite see how we're going to occupy 4 days in inquiry sessions. If we assume that I call, first of all, Mr. Baines for an inquiry session 1, and Mr. Finlay must tell me how long he'll be in cross-examination, but in chief, not more than an hour or so. And for his witness on that inquiry session, I would doubt I'll have more than 2.5 or 3 hours, say 3 hours cross-examination. In inquiry session 2, Mr. Welch, maybe an hour in chief, and for cross-examination, maybe of Mr. Finlay's witness, maybe 3 hours. Dr. Carver, unknown quantity, maybe longer depending on how many WLAs we're talking about. But even supposing Dr. Carver was a miraculous 4 hours, well, let's see where Mr. Finlay goes. I'm just thinking we're being a bit pessimistic here.
Mr. Finlay?
Well, I have 2 witnesses for the first session, and one of the issues in this case is how the current proposal fits in with the decision around strong leg. So there will be some cross-examination about that. I would, if the sessions go well, to deal with a witness, 3 witnesses in a day is very quick going in my view. I would anticipate certainly probably a day and a half plus for the first session. The second session, given what Mr. Trinick said earlier, that both witnesses are proceeding on the same assessment basis, I can see that Mr. Welsh and Ms. Anderson may take just a day, but again, they're quite, and they're only talking about one wildland area. But again, that might slip over into a second day. And with Mr. Carver, who's talking about more than one wildland area, 3 wildland areas, which Mr. Welsh will have to respond to. That's my cause for pessimism, that it might take 2 days. So I'm not usually pessimistic when it comes to giving of evidence. I'm usually the other way around, but in this case, I'm concerned that we set ourselves an unrealistic time estimate at the outset. It may come down, but it's better for it to come down rather than to go up.
Mr. Kelly, I don't know if you caught all of that, but I'm not sure if you've got any views on the timescales and what Mr. Finley's just said.
Well, if it helps you, sir, just looking at our inputs for inquiry session 1, as I'd said, it would just be myself giving evidence. I can't imagine my evidence in chief would be any more than half an hour for inquiry session 1. For inquiry session 2, irrespective of the number of wildland areas assessed, Dr. Carver's evidence is likely to be detailed. There will be a significant amount of mapping with his evidence. I would guess his evidence in chief would be about an hour. I was assuming that Mr. Trinick would want to spend quite some time with him in cross-examination. My inclination is that both sessions could take 2 days, covering the 4 days. In saying that, I'm being mindful of the protocol that's been issued for the conjoined Mori inquiries, where the reporters have indicated an indication of sticking quite strictly to the 10 a.m. to 4 p.m. time frame. So we're not going to, if you did the same here, we would not have long days. There'd only be a limited number of hours for each of the sessions. I've no very, very firm view, but I just think it's worth erring on the side of caution rather than finding ourselves rushed.
Based on that discussion, is there any thought, Mr. Trinick, that we should try and capture Monday as a start? I just get the impression that there is a possibility of the inquiry being completed within a week. 4 days might be tight, and whether or not it's in the interest of all the parties to start on the Monday.
The Monday would be, as it happens in that case, very, very difficult for me.
Okay.
I make a plea not. If we're going to take longer, I'd rather have entered the second week.
Okay. Mr. Finley, your thoughts on that? Tuesday start is fine.
Yes, and I think if we got all of the inquiry sessions out in week 1, we would be doing well, and we could dispense with all those witnesses, and it'll be effectively a change of guard for week 2 in any event.
And into week 2, is there any preference for the days? We have the facility booked actually from Monday to Friday, both weeks at the moment. Is it reasonable to allow at least a day for all the hearings? And would that be the Monday or the Tuesday of the following week?
I'd say the Monday, and that would do it.
Everyone happy with a Monday start for the following week, Mr. Finlay?
Yes.
Okay, well, I think at the moment what our discussion is indicating to us that we should start on the Tuesday, allow the 4 days, hopefully for the inquiry sessions to be complete. Would all, if we were to be exceptionally efficient and were able to move into hearings on the first week, would that be a preference, or would it be a preference just to go with a plan and have the hearings in the following week, Mr. Trinick?
I think so. Pre-COVID, I would have said, let's be flexible and deal with things as they happen in the first week. But with hotel arrangements and all sorts of things now, you have to plan in advance. So I think we have to stick to whatever timetable we set at the outset.
Thank you, sir. Mr. Finlay?
I agree, that's sensible.
Yeah, I think that certainly would be our preference. And to respond to Mr. Kelly's point about the protocol for other inquiries, those protocols will evolve. You'll note that I've indicated a 9:30 start until 4:30. Now that may have to change with regard to cleaning regimes and such like, but the protocol that we adopt for our inquiry will have learned from the experience of, I think, 2 inquiries in advance of ours. So that's why we're not considering a protocol for consultation at the moment. I think we see how things go, and we also have to consider the guidance in place at the time of our inquiry. So the protocol is likely to be issued a few weeks in advance rather than now. I think I've got a good handle on what's required, and that will assist with clarifying our booking for the facility as well. Is there anything else in terms of the programming? Be aware that I think the case officer will write out to you probably in the back of the note of the meeting, just to clarify witnesses and names and such like, and we'll slot them into the programme. So that will, I'll not ask you to list them again just now, but that will happen again, and so that we list all the witnesses expected, all the people that will be expected, in line with a programme that's produced. So on that, I think we can move to the first item 9 on the agenda. My apologies for doubling up, and this relates to an earlier point with regard to deadlines. We've discussed the 28th of August and the 11th of September for written submissions. I don't think there's going to be any problems with that. Hearing statements and any statements of agreed matters with regard to those hearings. We had indicated the 18th of September. Is there a thought within the parties that now we've clarified that we will have a hearing for policy and socio-economic matters, that deadline is reasonable or otherwise, Mr. Trinick, in terms of hearings, first of all?
I think
for hearing statements.
Evidence as a whole here. If you mean, yeah, inquiry reports and hearing statements, I'd rather deal with as a whole, because we see it as a whole in terms of programming the release of evidence, if that's okay. We'd already asked for the 13th of October, and in Karen's email of 20 August, she said that you'd be agreeable to the 2nd of October. And we're happy to keep to that date of the 2nd of October. That's fine for us. Subject to this issue of Dr. Carver, and we can't resolve that one finally today.
Mr. Finlay, do you have any thoughts? I was thinking that we may be able to agree a kind of phasing in of the evidence with regard to hearing statements first, but have you got thoughts on that?
Well, I think the 2nd of October for all evidence would work for us too. And we both have witnesses involved in the current inquiry, both dealing or on the edge of policy and on landscape and visual. And the 2nd of October would work well for us for a number of reasons. And I would accept that. I can understand Mr. Trinick's point, and it may be that provision should be made for Mr. Welsh to, if needs be, produce a supplementary report on evidence effectively to deal with Dr. Carver at a later date, and I would have no objection to that, but that's more of a matter for Mr. Kelly. But to have the general evidence by 2nd of October would I think be sensible given the party's situation.
Based on what you've heard, Mr. Kelly, do you have any comments to make, having all the evidence in terms of hearing statements and inquiry reports and any statements of agreed matters all submitted on the 2nd of October with recognitions on the 27th of October?
Those dates are fine with us. The only thing I would say in terms of the timescales is that in terms of the wild land assessments, we are proceeding on the basis of the wild land impact assessment included in the environmental impact assessment report. We are assuming that Mr. Welsh will not try and produce a new wildland impact assessment as an inquiry report, because that would be something we've not seen up to that stage. But subject to that caveat, those dates of the 2nd of October and the date for the preconditions are perfectly acceptable. And like Mr. Trinick said, I would rather everything was submitted at once rather than phased in.
Sorry, can I just come back on that? The reason, and I'm grateful to Ms. Finlay for a suggestion about a supplementary report, but it doesn't really help, because there is another inquiry, would you believe, which starts on the 12th of October in Argyll, where I'm involved, and so certainly Mr. Bell's involved, and that will take me out of commission in terms of reviewing any supplementary evidence that may come forward. So I really do want to keep to that 2nd of October date. As to Mr. Kelly's question, I'll come back to on what Mr. Welch will produce. It's a fair question. I haven't got an answer at the moment. But it is important that we say 2nd October is the date for all evidence and gear to that. And hence I'm putting pressure on Mr. Kelly, sorry Mr. Kelly, but to come back with Dr. Carver's position, because that may well necessitate quite a bit of extra work from Mr. Welch.
Mr. Kelly, we had touched on this earlier on, and I don't think we agreed a deadline, and we could do that now. Obviously, in terms of what we'd agreed before, we were proceeding on the basis of the information you had provided earlier, which was a focus on 3 wildland areas. Would it be reasonable that perhaps by the within a week or two that you'd be able to clarify that? The only reason I'm asking that is really so that we can adhere to the deadlines and that we don't run into the difficulty with regard to the timetabling of this evidence in advance. Do you think a week or two to clarify the scope would be fair?
I would ask for 2 weeks, because we don't actually have the data just now. We have the data for Glenshero, and we have a promise or an indication from SSE that we'll have the data for Strawnlairg and Cloyk tomorrow. Mr. Gillis has not yet clarified when we will get the data for Dell. So I'm happy to help by responding, but I would ask for 2 weeks, not 1.
I'm just checking my diary. That would be around the 9th of September. Does that make sense? Mr. Trinick, if Mr. Kelly is in a position, he's offering to try and get that information within 2 weeks. Does that sort of time scale help in terms of programming in additional work if need be?
It wouldn't help to get it before then, because Mr. Welch is in the inquiry with me next week and can't do much before the 9th of September anyway. But I think that is the last date, because Mr. Welch, I don't know how much he's going to be required to do. I may yet come back to you and have to have a more general conversation about timetables if a great deal of work is involved, which wasn't anticipated. But let's take it from there, say the 9th of September, and I'll go back to Mr. Welch after this meeting and get more soundings from him on what his availability is between the 9th of September and the 2nd of October in terms of what he may have to do.
Okay. Well, I'm happy to capture in the note that the 9th of September, Mr. Kelly will get back to us. But I think you put your hand up there, Mr. Kelly, so I'll let you in.
Yeah, I mean, I understand the concerns, but in fairness to my witness, and I don't want to stray into discussing the evidence or the merits of the case, since starting out to look at this issue, we've discovered that SNH did not map the effects of Strone Lairg on the wildland areas. So we already have an additional tranche of work to do because SNH didn't do this work in 2014. So we will try our best to assist the inquiry process, but it is a hefty piece of work that we're now having to undertake to look at the mapping of these wind farms on the wildland resource. But I will commit, as per you confirming in the note, that we will respond by the 9th and confirm the extent of Dr. Carver's evidence in terms of the number of wildland areas. I'm very happy to do that.
Thank you for agreeing to that and for not straying too much into the evidence here. Mr. Finlay. I think you'd have to unmute your mic.
I've muted instead of unmuted. We're not permanently involved in this dispute. 2nd of October works well for us, and the date when Dr. Carver gives his evidence is to ourselves.
Okay. I didn't catch the end of that statement. Sorry, Mr. Finlay. Do you want to repeat that?
Yes. When Dr. Carver provides his material, it's not going to be particularly relevant to our witness, because we are only concerned with one wildland area, and we are will be ready to produce our evidence on that by the 2nd of October.
Okay. So we've all agreed the 2nd of October for the submission of all documents. Can we, given I said documents, can we agree a date for the actual submissions of core documents and parties lists of documents? Do you want to make that the same date or earlier? Is there any preference? Certainly not later. Mr. Trinick.
In terms of the documents, yes, 2nd of October. In terms of the list of documents, and a lot earlier, because those documents, especially in current circumstances, take much more time to bring together than they would otherwise.
I would certainly welcome an earlier time scale, but Mr. Finlay, any thoughts?
To a certain extent, finalise the documents when you're producing your evidence, but I can see the sense in trying to have a list of documents agreed or certainly started well before the 2nd of October. And I'm happy for Mr. Trinick to propose a date, but I'm sure we will be very happy to liaise with his side as to producing such a list.
Can't do it now, but we'll come back to you within 2 days of this meeting with that date, sir.
So for the purposes of our discussion today, are we content that we have we look for an earlier agreed date for the submission of documents and lists, and that it would be earlier than the 2nd of October, but no later than the 2nd of October?
Well, so I think witnesses are already starting to prepare their evidence. That's what produces the thought process leading to what documents are required. I would hope that by mid-September, there should be some clarity about what documents are needed. I mean, 90% of them are the ones you see at every inquiry, frankly. They're pretty easy. It's the ones around the margins of the inquiry topics and the hearing topics, which may take more time. But I think if you were to set a deadline for mid-September for core document lists, that will help Wright Johnson Mackenzie in particular bring those documents together.
So if we went for Friday the 18th of September?
Grateful.
For the lists. Mr. Kelly or National Park and Scotty, any thoughts on those dates? No issues?
Sorry, Nina, for the National Park. I'm just thinking through in my head in terms of process, in terms of us responding and like providing a hearing statement. Obviously, it would be useful to refer to the core documents within that, but there may be other documents that we want to refer to in it. So I'm not objecting to having an earlier date, but there might be additional documents that we might want to add as we finalise our hearing statement. That's the only issue that I might have.
So from our point of view, that is bound to happen. It always happens. And yes, I mean, provided the additional list doesn't overweigh the original list, I'm sure we'll be all right with that.
I think in the current circumstances, we would really want to minimise the submission of late documents. So we would be looking for the core document lists and the lists of the parties to be as comprehensive as they would be. Notwithstanding, there may be the odd item that is required to be submitted after, but I would really look for the parties to be gathering together a complete list. Mr. Kelly?
I'm perfectly happy with what's being suggested. It's the process we've followed for the conjoined Moray inquiries of drawing up a document list early for core documents and including within that the scope for adding in extra documents. That mid-September date's fine. Our documentation will not be extensive, so very happy to cooperate. Okay,
thank you very much. I think I've got a agreement there. On the matter of the EPA issuing general guidance and a protocol, is the 9th of October, which is essentially a month or so in advance. Everyone happy with that? We will have some learning from other inquiries, at least one inquiry at this venue. So that's when I would plan to issue a protocol and start to share risk assessments and such like. Everyone content with that? There will be an opportunity to contribute. That's why I'm allowing a month in advance, so that if there are any issues that need to be discussed, we can. I would, in terms of hearing agendas, given that some of the material won't be in as early as anticipated, then the hearing agenda might be a bit later than the 9th of October. And I'd have to just double check my own diary, but I would guess that I would be issuing the draft hearing agendas on the 23rd of October, which is essentially 2 weeks before, and probably allow 7 days for parties to raise anything in particular. Does that timescale seem reasonable?
Yes.
Given that the hearings are planned for the end of the process. So we'll go with agendas circulated on or around the 23rd of October, and allowing 7 days for any issues, if there are any, to be raised. And they would then be reissued. The same goes for any protocols that were circulated. We will circulate a finalised set of protocols for the inquiry with regard to COVID-19, and that will be in advance of the inquiry, and all parties will be asked to make sure that everyone is aware of them. Quite extensive documentation, perhaps, and I think a number have seen some early drafts already on that. In terms of item 9B, I'll call it, and that is talking about the protocols for oral procedures. Some parties may be aware, but we do have a risk assessment from the venue, and the DPA staff have visited the venue. We'll be carrying out our own risk assessment and a hazard action plan, as well as a kind of operational document, which will be a protocol for the operation of the inquiry. Some of the key matters that will be in there will be to minimise attendance from the public. It's likely there'll be little or no public allowed in, because it will be webcast. The plan is to webcast. Physical distancing in place, obviously. There'll be a programme, and we will allow more time for the changeover of witnesses. We may use adjournments and breaks more regularly. we'll have a programme of, as we've discussed today, and the case officer will ask for witness names in relation to those programme. They'll be registering each day at the hotel, and I think that could well be through an app. So the hotel has to adhere to its protocols. There'll be details with regard to face coverings and masks, and how we will work in terms of documents, in terms of electronic working. There is a maximum of 30 people being imposed by the hotel. However, that's not a target. What we will be seeking to do in our protocol is minimising the number of individuals in the room, because that will assist in reducing risk. So that's, in broad terms, I think these are some of the matters the protocol will cover, but we do plan to learn from the first inquiry and feedback. Is there any particular point any of the parties would like to raise just now? One matter was electronic working I was going to ask you about, in terms of whether you had any thoughts. We are planning a slightly larger inquiry with more complex electronic working, but if you had any thoughts about everyone being self-sufficient in electronic working for this inquiry. Mr. Finlay, you had your hand up.
Well, so I may have missed it, but I wondered whether you'd set a date for precognitions.
Oh, sorry, I think that was the 27th.
27th
of October.
Grateful. Then as to electronic working, and council and Nature Scott should be sufficiently well resourced to work electronically to a significant degree.
Mr. Trinick? Electronic working,
Sorry? We have no issues with electronic working.
And Mr. Kelly, in terms of electronic working, do you feel that you'll be self-sufficient on the day in terms of access to documents? I think you're going to have to unmute your microphone, Mr. Kelly.
Hopefully hear me now. The way things have worked out with the conjoined Moray inquiries, it's fine having most of the documentation on a USB stick, so I don't see any difficulties. In terms of the protocol, there has been a number of two concerns. Myself and the Rothas 3 applicant have expressed concerns about the exclusion of the public. I don't think there'll be such a significant public interest in this, the Glenshero inquiry, but maybe just let's see how the lesson goes from the first inquiry in terms of excluding the public and take it from there.
Thank you for that confirmation. Obviously, on that matter, I think you'll probably find that the DPA come to a view on that and set down what will happen. But we'll learn from the first. Our key matter is minimising risk, key issue, but still to hold the inquiry and allow fair process, but to minimise risk at the same time. So. Is there anything else with regard to the protocol? All happy that you'll get to see a copy. There will be learning. I know that some of the parties may be involved in other inquiries, so we'll all benefit from that experience and be able to come up with perhaps a slightly revised set of protocols. We also have to bear in mind that things may change rapidly, and we may have to look to change procedures that have been in place in other scenarios. I haven't booked a breakout room for this inquiries. Does that pose any particular problems? I hadn't planned to do that, but if there's any specific requirements, then perhaps you can deal with the facility yourselves if a party would wish that, but we haven't booked one. Mr. Trinick.
That was just being raised with me. Yes, we will need a breakout room, but shall we deal with the hotel direct, or do you want us to come through you?
I think we haven't necessarily planned for that, and if it's only one party that's looking for that, then my advice just now would be to deal directly with the hotel, but to copy in the case officer, just so that the case officer is aware of what the parties are up to. Mr. Finlay?
I imagine we should break out room as well. But we'll follow the same procedure that you've just suggested to Mr. Trinick and keep everyone involved notified.
Thank you. Thank you for that. If the final matter is on this item is really, if guidance changed dramatically and there is a need for a contingency, which isn't what we've been planning for, then my suggestion is that we would meet as urgently as possible to discuss the implications. I don't think there's any merit in having a long discussion today. So if everyone's agreeable that if matters change drastically, local lockdowns or the like, then that we would meet as soon as everyone's available to discuss the implications. Are we all content with that? Yep. Okay. AOB, Mr. Kelly, you've indicated that you don't need to ask the questions that you're going to ask in your email. I think I was going to ask the applicants were indicating that there was additional guidance with regard to unaccompanied site visits. I don't know if that was something that you were still going to produce. It's not necessarily needed from my point of view at the moment. I've visited a number of the viewpoints already, but that was a matter that was a little bit outstanding. Mr. Trinick, have you got any comment on that? That was additional guidance that you'd thought you might prepare for site visits.
I don't think that's going any further. That's a dead issue.
That's
I
fine.
do have one item of AOB though.
Please go on.
One of the disadvantages to preparation for the inquiry of COVID has been our inability to get out on site, particularly Mr. Welch, who, as you know, was reasonably recently appointed to the project. And very extensive site visits have now taken place, and they've led to a position that we wish to offer a condition allowing you and the ministers to delete 4 of the turbines. We're not amending the application, but there is a wish to put forward an alternative consent whereby only 35 out of 39 of the turbines would be built. In order to enable you to consider this, we would need to produce some environmental information, which in normal circumstances would need to be advertised. I'm going to, well, we'll put it in writing, obviously, but the request will be made to you in writing to deal with this matter under Regulation 19, requiring the information to be provided for the purposes of the inquiry. And we can produce that information within 5 weeks of today's date. That's not to say that we can't tell all the parties well in advance of that 5 weeks what the single change, the deletion of 4 turbines by condition would be, but the information will take 5 weeks. So out of courtesy on this call, I want to brief all parties of the position which has arisen, and we will be in touch very quickly after this meeting with all parties to explain what that offer is. Thank you.
If I can give the parties an opportunity just to come back on that. Mr. Finlay first, perhaps.
Well, 5 weeks would appear to take us to the 2nd of October or thereabouts. I haven't had a chance to check it in my diary, by which time reports will be due, which potentially puts significant pressure on our witnesses if they haven't had the information beforehand. I hear Mr. Trinick's offer to appraise us all of the turbines that will be removed, but if the information could be available, or even part of it beforehand, that would make our life much easier, rather than effectively having to deal with it by way of rebuttal.
That's a very fair point. And what we can do is almost immediately produce wirelines, just generate some wirelines showing the position without the 4 turbines with some very basic explanatory text. That can be done within a week. We could do that quite easily. And then provide, it won't actually be much more text, but nevertheless, the environmental information, call it 4 weeks, not 5 if you want, but we will appraise you of the position almost immediately.
So the offer of 4 wire lines within a week or so, I'm not going to hold Mr. Trinick to the exact dates, and some explanation is gratefully accepted. And if the other material was available a week before the deadline for reports, that would be gratefully accepted.
Ms. Caudry or Mr. Kelly, do you have any comment to make?
Yes. If the changes resulted in a significant change to the effects, we would likely have to take the proposal back to our planning committee to seek their views on it. There isn't a planning committee in October. The next planning committee after September's one, which I think is the 26th of September, it's thereabouts, is the 13th of November. Now, obviously, that would cause us significant issues in terms of like what our position was and how we addressed policy in our hearing statement, because the emphasis would depend on what the effects were. So it's potentially causing us problems, but we would be relying on Nature Scott's landscape advice to inform whatever we put to committee. So it's a bit difficult to prejudge because we don't know what the missing 4 turbines out would actually mean in terms of significance of effects, but it potentially does cause problems for us.
And Mr. Kelly.
It quite obviously is going to cause problems for Dr. Carver's evidence, because he relies on looking at the precise location of the turbines and then mapping various wildland attributes based on that. I just have to express concern. I can't say anything further until we see the information and then take it from there. It could affect timings. I hope not, but it could.
If therefore we said, it's now Wednesday, that we would produce wirelines showing the proposed to be conditioned turbines by, say, next Monday. Now, you haven't got your data yet, Mr. Kelly, so hopefully that'll be in time not to prejudice Dr. Carver preparing his evidence. And I hope that might also assist Nina Caudry and CNPA in terms of putting something to the September meeting of the committee, at least to say this is what's proposed. I hope that might help.
I think I would, in the first instance anyway, I think I'd look for the applicant to potentially put it in writing to us, because you've indicated it's not what you propose. You said you're not amending the application, you're not suggesting the deletion, but that may come out of the evidence as an option for ministers. So we would probably want absolute clarity as to whether or not you plan to amend the application and all that means, or if it's just a matter that flows out from your evidence. It may well be something that we have to deal with in terms of further information and further evidence afterwards. So I'm not going to give you an answer just now, Mr. Trinick. I think I want to know what you put in writing. But I see the potential issues that others have raised and the problems that might cause if it's not a firm proposal for change, or if you're not proposing all the turbines that are proposed at the moment. So I think it would be best if you put that in writing, and then we can consider it, and then it gets back to all the parties. Mr. Kelly.
When Mr. Trinick gives you that in writing, can he just clarify if it would be the applicant's intention to give evidence on 2 schemes at each session of the inquiry? The original scheme and a conditioned scheme minus the 4 turbines, because that might affect the inquiry programming. I should say that in the Murray case, the conjoined inquiry case, where there are options, the Rothes 3 applicant's landscape and visual impact assessment witness is giving 2 sets of evidence on 2 schemes, and it would be useful to know if this is what's proposed for Glenshero, assuming you agree to proceed.
Mr. Trinick.
They're all fair points. And I'm not going to say any more now, except that we will send a proposal to you by next Monday, latest.
And then we can take it from there, and we'll keep all the parties aware of what's on. Mr. Finlay.
Just a request to Mr. Trinick, as well as wirelines, if he was able to produce amended ZTVs as early as possible, that would also be of assistance.
That's not difficult. We'll certainly do that as well.
Thank you.
Thank you. And once we've seen what you put in writing, then we'll work out how we manage that in the post. Raise? No, it doesn't look like it. Well, I'll prepare a note of this meeting. It'll be in conjunction with the previous note. I'll not say it supersedes it. Where it does supersede it, I'll say that it'll take account of our discussion today, some of the matters that we have agreed to, and then it'll be circulated and onto our website. So thank you very much for your assistance today. We'll look to close the meeting just now, and one of my IT colleagues will probably switch everything off, but hopefully we'll adhere to all the deadlines that we've agreed to, and we will see you, or some of you, either at a site visit or in Abbeymoor in November. Thank you very much.